Since the release of the last video discussing where and how Diddy is being held, only a month has passed, but there's already new news on the topic, especially in light of the recent attempt to secure bail and significant public concerns. Hello everyone, welcome to Anna's show. As always, I'm your personal celebrity detective, star secret thief, call me what you like. Today, I'm in prosecutor's attire, and that means, even if virtually, we'll try to step into the courtroom to find out how Diddy requested his release. Today, we'll talk about the judge change proposed by Diddy as part of the new bail release package, how he and his lawyers are trying to invoke the Fifth Amendment, and why the district attorney of the Southern District of New York initiated Diddy's unexpected withdrawal from his powers. To set the stage, I propose we start this video by analyzing all his bail attempts because even I, while reading all his letters and the responses from prosecutors, constantly get confused by his communications. Who denied him? Which judges were involved? Why new names appeared? Who were these people? And where Diddy disappeared to next? The first attempt at bail came the day after Diddy's arrest when he proposed $50 million in assets. The request was denied by U.S. District Judge Robin Tarnowski, who supported the prosecution's claim that Diddy posed a potential risk if released under house arrest. As we know, Diddy did not give up. They came up with a new proposal and were denied again the next day by Judge Andrew L. Carter Jr., who confirmed the decision, stating that no bail conditions could eliminate the risk of pressure on witnesses from Diddy. During the same hearing, Diddy waived his right to representation. It took time to prepare a defense strategy for an emergency court hearing, but his lawyers were unable to provide a date, as stated in the judge's declaration. As a result, Diddy had to recuse himself. However, the problem was that the judge had previously worked with the attorneys Diddy had chosen, so he could not continue to hear the case. The case was reassigned to Judge Aaron Sabermenian. The judge change allowed Diddy to make a third bail request. To understand this, it's important to know that, according to the law, a defendant has the right to request bail as many times as they wish. After the first denial, a judge must review and clarify details that could be crucial in making a bail decision. In early October, Diddy's team began preparing a new proposal. At the same time, they filed an appeal as a three-judge panel from the Second Circuit Court of Appeals in New York reviewed the legal team's request for release. They submitted a motion for immediate bail release to the Federal Appeals Court. On October 11th, U.S. Federal Appeals Judge William J. Nordini denied the motion for immediate release. In other words, before the three-judge panel made its decision, he tactfully asked them not to get ahead of themselves and to wait for their colleagues' response. The attorneys argue that new evidence has emerged in the case, which not only changes the understanding of what happened to their client, but also points to potential bias on the part of the government. They accuse the prosecutors of distorting and hiding crucial facts, including the alleged editing of the sequence of events that took place in March 2016 in the video. The attorneys claim that the prosecutors intentionally distorted an episode of violence involving witness number 1 to portray Diddy as an extremely dangerous individual and influence the opinions of the two judges who ruled against bail. They allege that the government has a more complete version of this video, presumably the version the world saw when it was released, but instead, they altered the sequence of events to provide convincing evidence of danger and obstruction of justice. While the prosecutors argue that the video depicts witness number 1 attempting to flee one of the wild altercations, they state they have a statement from the escort service employees who were present in Diddy's room at the time. This statement claims that the video is unfortunate proof of a domestic altercation that occurred between Diddy and his partner as a result of long-term, mutually toxic relationships, but it is not evidence of his guilt in human trafficking or coercive violent acts in December. This means that timelines and tasks are gradually becoming pressing, increasing anxiety in moments when it feels like you are no longer in control of the situation. Endless tasks only stoke the inner anxiety, intensifying the already nerve-wracking anticipation of the end of the year. Talking to a specialist from SAP Psy can help. This online psychological counseling service is available during any difficult moment. The service allows you to consult via chat, exchange voice messages, or conduct consultations over the phone. For example, I don't like long conversations, so the ability to message a specialist at any time and then go back and read the conversation to reflect on it seems like a very useful feature. By filling out a detailed questionnaire about yourself and your problem, you will receive recommendations for choosing a specialist, whom you can always change if you don't feel that essential connection that is so important when selecting a psychologist. Scan the QR code on the screen or follow the link in the description of this video, subscribe right now, and get a discount of 600 rubles or €9 for the first week of using the service with the promo code, the show. Don't forget to take care of your mental health. Sai will help you with that. Alongside the third bail attempt, on October 28th, the so-called prison raid took place. In our view, the unexpected search of the cell and questioning of inmates, part of a procedure initiated by an independent representative of the authorities, involved searches for prohibited items, ranging from rolls of toilet paper to books and notebooks. I want to draw your attention to one detail. While it is called an unexpected inspection, this only applies to the inmates. I think the reasons for this are clear and understandable, and of course, since we are talking about what the inmates did, Diddy could not miss such a unique opportunity to try and understand the Fifth Amendment of the Constitution. The Fifth Amendment states that a person accused of a crime has the right to due process of law, cannot be tried twice for the same offense, and cannot be compelled to testify against themselves. In simple terms, Diddy has the right to keep legal secrets with his attorneys as they build his defense, and no one has the right to disclose these secrets dishonestly before trial. If this right is violated, the accused is immediately removed from the courtroom, and all charges against them are dropped. It is impossible to bring the accused back on the same charges. On the eve of the bail hearing, Diddy's team makes a bold move and demands an emergency hearing in connection with what they describe as wild government misconduct, which led to cases related to Diddy's matter being dismissed. Special status, or as they call it, privilege, is a legal standard that protects information within certain relationships from being compelled to be disclosed during court proceedings. One such long-standing privilege that applies in all legal situations is the attorney-client privilege. The judge granted the attorney's request and scheduled an emergency hearing for November 18th. During this hearing, Mark Knife stated that during the wild search, the prosecution obtained Diddy's notes from a legal notebook, which constitute that very privilege. This sparked a battle over the Fifth Amendment and Diddy's freedom. Diddy's legal team began the hearing with a claim of an unprecedented violation of the accused rights and demanded to be provided with the surveillance camera footage and detailed information on who conducted the search, who appointed this particular officer, and what instructions were given. According to their information, the search, conducted solely to sabotage their client, resulted in the unlawful acquisition of information from legal notebooks, which are considered protected by the attorney-client privilege. When you hear about legal notebooks, or as they are also called, legal pads, you should understand that these are usually yellow-paged notebooks with a perforated top. These notebooks are known not only for their yellow pages and blue lines, but also for the distinctive red line that leaves a margin on the left side for notes. A small historical note: this margin was requested by a judge, I believe in 1900, so he would have a place to leave brief notes while reading what was written in the notebook. In general, these notebooks are well known to both civilians and especially to law enforcement officers. During searches, it is strictly prohibited to seize or transfer any information stored in them to the prosecution. The prosecutor challenged the attorney's claims, stating that the cell search had been planned before Diddy's arrest and had lasted a week, as it involved working with all the inmates. Diddy was not the target of the search, but this did not satisfy the attorneys. Additionally, according to the prosecutor, the prosecution did not have any records from the legal notebooks, and any information that might confirm a violation of the detention rules would be complicated by the privilege, as the notes relate to Diddy's defense. The prosecutors argued to the judge that they were not obligated to inform the defense about the progress of the investigation or the evidence they had. They also stated that there was no expectation that personal notes with a title like to-do list, which specifically refer to obstruction of an investigation, would not be examined by the prosecutors simply because the word legal appeared somewhere in them. I want to make a brief digression for those who aren't subscribed to my channel, because everyone who is subscribed is already familiar with the information I'm about to share. To prevent the prosecution from compromising itself or undermining the charges, all copies made are first transferred in accordance with regulations to URL, a designated team of independent individuals who have no ties to the case conducts the investigation. This team filters all the documents received and decides what can be reviewed by the prosecution and what cannot. Knowing how thin the ice is that the prosecution is walking on, I think they genuinely wanted to read all the pages, but first sent them for review. Out of all the pages, they only received 16, and with these 16 pages, they began working in a way that revealed something surprising. When they obtained 16 pages from the notebook, they discovered that Diddy had not signed what was supposed to be done. The prosecution found out that Diddy had contacted one of his children and asked them to reach out to someone who could help investigate and gather information about witness number 2. The prosecution also pointed out that this note was not addressed to any of the lawyers, meaning it could not be protected by privilege, but it clearly demonstrated how Sean Combs was obstructing the investigation, even while behind bars. Additionally, in letters addressed to the court, the prosecutors stated that Combs was violating prison rules by actively obstructing justice, using other inmates' phone cards to contact potential witnesses and influence public opinion regarding his current legal troubles. Here, I believe Diddy's defense team might have been caught off guard, but as you know, the American legal system is a grand performance where expensive lawyers and less costly prosecutors pull out their trump cards from their sleeves and continue the show. Just when it seemed the emergency hearing was nearing its logical conclusion, Mark drew the judge's attention to these 16 pages and submitted them for examination, stating that this was not just a page from a personal notebook, as claimed by the prosecution. It also contained a page from a legal notebook marked with a note. Due to this violation, the prosecution now knew about one of the witnesses they wanted to use in the upcoming trial. The judge found that this page drew attention to the note and paused the hearing for further examination, which Diddy's defense team gladly agreed to. After reviewing the materials, the judge ordered the defense to destroy all 16 pages without any possibility of referencing the information they had learned. As you can imagine, this information pertained directly to Diddy's work with witnesses involved in the case. The prosecutors submitted their copies of the pages, which did not include the mark, suggesting that Diddy added it after the review. Nevertheless, the pages had to be destroyed. Here's how Diddy's small victory played out. While he failed to use the Fifth Amendment to gain his freedom, he managed to destroy pages that could have refuted the prosecution's claims that he should not be granted bail during the upcoming bail hearing. This brought him one step closer to the day he had been waiting for, a day that marked the culmination of this entire spectacle he had orchestrated. As part of his new bail proposal, Diddy offered the same $50 million in property, including his Florida home and a GPS tracker at his mother's house, as well as surrendering his family's passports. However, the agreement was specified only for his sons, with letters of guarantee from his mother and daughter, and house arrest in an isolated residence without phone or internet access. Meetings would be limited to his legal team, and private security would provide 24/7 protection. According to his lawyers, the security team's phones would be monitored, all calls would be documented, meaning Diddy would face stricter conditions at home than he would in detention. This raises a logical question: why is he being granted bail when he would actually have more freedom in prison than under house arrest? Or is he planning not to adhere to his promises? The judge suggests the prosecutor consider the proposal, but Christina Slavic responds that any discussions about bail must stem from trust in Diddy, which is now non-existent, especially when taking into account his behavior while incarcerated. Not only has he been denied bail twice before, but he also continues to violate prison rules, undermining any trust the prosecutors might have in him. The prosecutor questions the trustworthiness of Diddy, asking why he would be trusted under house arrest if he can't adhere to detention rules. The judge asks for clarification on whether the prosecution's argument against Diddy's release is based on his wealth, as was the case with Busta. In this case, the court ruled that wealth alone cannot be a reason to deny bail. For those unfamiliar, It's important to note that in the United States, precedent law is used. This means that judges and participants in legal proceedings can reference how laws have been applied in previous cases. For instance, Diddy's team might cite the case of Mark Jeffers, former CEO of Abercrombie, who was recently granted bail of $10 million on similar charges. The argument for Diddy's continued detention was not his wealth, but rather the danger he poses, the risk of flight and obstruction of justice. The judge then clarifies that obstruction of justice is the main argument, while the prosecution emphasizes the risk he poses to others. The judge continues to ask for clarifications. What exactly do they mean by an obstacle for the judge? The prosecutor states that Diddy attempted to contact witnesses and violated restraining orders, which he himself had requested. Additionally, the prosecutor points out Diddy's behavior, recorded by CCTV cameras, in which he disguised himself as a buyer. This evidence is crucial for the court as it demonstrates why he should not be granted bail. He is prone to violence and intent on concealing his crimes, and the evidence against him continues to mount. Reports of beatings and threats from employees of Partners surfaced, highlighting Diddy's aggressive actions. Alexandra Shapira, a lawyer from CompSA, cited two well-known cases where bail was denied: the LaFontaine case from 2000 and the Godey case from 1996, where an accused individual instructed someone to lie over the phone while in pretrial detention. In the case of the head of the Gambino crime family, a witness was attacked. The government has not presented similar evidence in Diddy's case, implying that he does not obstruct justice to the same extent. Diddy's legal team has suggested that the prosecution's motivations are racially biased, arguing that the charges stem from a reaction to a wave of negativity. They maintain that some of Diddy's messages were simply appeals for witnesses to be truthful and to speak with his lawyers. After listening to both sides, the court requested Diddy to clarify where he would live if released on bail. Mark Knife mentioned a house, but could not disclose the address. Upon further questioning, it became clear that this referred to Diddy's Florida residence, which the judge deemed unsuitable. The judge asked for a New York-based residence. Knife then proposed a 3-bedroom apartment guarded by a private security firm, with 1 guard inside and 2 outside, complying with strict bail conditions 24/7. Knife added that Diddy would avoid any contact with individuals unrelated to his legal team. He stated that Diddy had the right to make this request, and the team was preparing for the trial set for May 5th, aiming to conduct a thorough investigation. Christina Slavic pointed out a video Diddy posted on Instagram on November 5th, which appeared to be deliberate. In the video, Diddy's children called him from prison, singing "Happy Birthday, Daddy," and showing support. Despite his lawyer's warnings, Diddy insisted on posting it. This act became a significant argument for the prosecution, showing Diddy's disregard for court orders and demonstrating that he would likely not comply with bail conditions if released. The court requested Diddy to submit written statements by November 25th. As many viewers were tense, this deadline was crucial because prior refusals by the court had been made on the same day, whereas positive decisions typically took days. On November 25th, the chief prosecutor of the Southern District of New York, Damian Williams, announced his resignation. Appointed by President Biden, Williams had overseen the arrests of notable figures like Senator Bob Menendez and New York Mayor Eric Adams. Speculation surrounded his departure, with one theory suggesting it was due to a power shift in leadership. Another suggested that Williams was anticipating dismissal and wanted to leave on his terms to retain benefits and pension. There was also a theory that the bail decision was influenced by the timing of Diddy's case. Diddy's team began preparing the apartment with surveillance cameras and monitoring systems, anticipating an eventual positive decision. However, on November 28th, the court announced that no decision would be made until the end of the week. On November 8th, 2024, Diddy renewed his bail application, leading to a hearing on November 22nd. On November 25th and 26th, both sides submitted additional letters. The court ultimately rejected Diddy's petition. Judge Aaron Sarman concluded that no condition could ensure public safety if Diddy were released. The court highlighted evidence of Diddy's aggressive behavior in a 2016 video, including unedited footage provided by the defense. It also noted Diddy's attempts to contact and intimidate witnesses and violations during his pretrial detention. He paid inmates to use their phone access codes for calls to unauthorized contacts and instructed family members and others to join three-way calls to complicate communication. The court ruled that Diddy had not shown that temporary release was necessary for trial preparation. Despite having access to legal resources and documents, he failed to demonstrate any need for early release. Thus, the judge denied Diddy's bail again, presenting further challenges for his legal team in seeking conditions for his release.